Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. Senators grilled anew some members of the executive branch, including law enforcers behind the arrest of former President Rodrigo Duterte. Duterte allies questioned why the former president was not presented before a local court as required by law before he was turned over to the International Criminal Court or ICC. Justice Secretary Jesus Crispin Remulla invoked again the executive privilege, saying the reason why they did not attend the hearing before was because they did not want to be bullied. Let's get on point with former Senate President Franklin Drilon and former Presidential Spokesperson Edwin Lacierda. Gentlemen, good to have you. Nice to see you both.
Thank you for having us tonight.
All right, there's a lot to talk about. Senator, hindi niyo po napanood yung hearing kanina, ano po?
Pagod na ako sa mga hearing sa Senado.
Sa dami ng hearing.
24 na taon.
But
Edwin
was able to watch it. Just give me your brief assessment of today's hearing. This is the third.
See, my question here is, you're supposed to conduct a hearing in aid of legislation. I really don't know what's the purpose of that in aid of legislation when it came to the questions asked, because it was all trying to reconstruct the events. So, look at it, so they were questioning, for instance, General Torre, about this doctor, 3 hours na, and then he would answer, but they would insist on their own truth. So there's really, and it's really more of trying to gain, the audience there is really more for the Dutertes. I think, because I can't, for the life of me, I don't see the purpose of that.
There's anything that you can possibly see in aid of legislation, because there were further questions asked. For instance, any arrest warrants that will be issued in the future for possibly some more suspects in this crimes against humanity case, maybe the Philippine government might be able to handle it in a different way, and maybe that could be a way of enacting a law in aid of legislation. Senator, do you see anything that might lead to that?
Well, the administration will argue that there is sufficient law at this point when they served the warrant on the former president and had him brought to
The Hague.
The Hague. So they are asserting that there is sufficient law at this point. And the issue of, we mentioned in your introduction, that the insistence that we must first go to the court, that's only good where there is extradition. This is not a question of extradition.
Okay,
but on the thing of crimes against humanity, FMD, we're no longer part of ICC, so
yeah.
So what are you talking about international arrest when we're no longer part of
it? It's good you raised that.
It's arguable. The argument on the other side is that these crimes were committed while we were still members.
No, moving forward, because we're talking about future legislation. Okay. So why are you talking about that?
So what could be maybe just to answer that, could there be any legislation that can come out of this particular hearing for future incidents or arrests?
Well, I don't know, but if you ask me, there is sufficient legislation at this point. If they want to clarify it, well, they can have it.
I agree with Senate President Drilon, because apparently Senator Alan Cayetano was invoking a particular law which they claimed that the PNP violated. So there is a standing law already.
Okay, for context, let's talk about that. Senator Alan Peter Cayetano was talking about a particular law that allows an arrested individual to seek allow visitors from his family, seek his or her personal doctor. That's why they were questioning that, because what came out, Senate President and Attorney Edwin, was that during that 10 a.m. to 11 p.m., let's say 13-hour stay of the former president from the airport to Villamor, there were people, individuals, who were not allowed to enter, such as Vice President Sara Duterte, who's the daughter. So sinasabi ni Senator Alan Peter Cayetano, dapat pinapayagan yung mga yon dahil miyembro sila ng pamilya. What do you say to that?
I agree. What law is violated if you allow those people to visit? They are entitled to even in the worst criminal, they're entitled to visitation, even while they are serving their terms in final judgment. This one, the former president, he is certainly entitled to adequate medical attention while he was under detention already. He was entitled to visits from his families. And in that particular instance, I think they did not handle it correctly.
All right. There are a number of arguments that have been raised, and I'm actually excited to get your thoughts on the arguments that were raised. Well, first, before I go to the arguments, I want to ask you both two things. Was the arrest order legal? That's the first question I want to ask you. And then the second is, was turning him over, the former president, to The Hague, legal? So, arrest order legal, and turning him over, was it legal? Attorney Edwin, go ahead.
Senator Drilon, you go ahead. Well, you're going to question that on the basis of the Philippine jurisdiction. But, you know, whenever it comes to, here's the situation. Even if you invoke the Constitution, in our case, vis-a-vis an international treaty, in international law, the Constitution is considered municipal law. And what will govern is the international treaty that we entered into. So when you're talking about the legality of the arrest, they will be invoking the laws that would be applicable. Insofar as I'm not familiar, I'm not a international criminal court practitioner, so I'm not familiar with those laws. But definitely there must be some color of legal title, legal authority there, because otherwise they would have been easily stopped by the Supreme Court, if at all, because there was already a TRO that was petition for injunction, I think, or TRO.
Yeah, that day.
Or habeas corpus by Attorney
TRO
General.
first, and then a habeas corpus.
Yeah.
So could you answer my question? Do you think the arrest order was legal?
The arrest order coming from
The ICC?
The Hague.
Yeah.
Yes.
Okay.
Because at the time, as what Senator Drilon was mentioning, he was being charged
Okay.
at the time when we were still part of the Rome Statute.
And so, and then turning him over to The Hague, was that also legal or not?
Well, they were serving a warrant of the International Criminal Court. They could not surrender him to any local court. And it is in fulfillment of our international obligations, the theory of the administration, in fulfillment of our international legal obligations, that we arrested him and turned him over to the ICC. And by the way, all these questions of jurisdiction, to me, is laying the basis for an argument before the ICC that they should not be tried in The Hague. That's what it is all about.
That's why there was an information file before the ICC. So basically you're saying that when the argument of they have no jurisdiction over the former president, basically you're saying that's not true.
That's true.
Yeah, because there's already jurisprudence. Nagsalita ng Korte
Yes.
Suprema hinggil dito. We are still obliged during those times that we were still a member of the ICC, which was until 2019, even if we had left or formally told them we were exiting in 2018 kasi meron pa po yung 1 year
That's
period.
very clear in the Constitution of the International Criminal Court, which we ratified in the when we voted for the ratification as a member of the UN.
You were part of that, Senator Drilon, di ba?
Yes.
Yeah, you were there.
The Senate ratified the Rome Statute.
Right.
Yeah.
Yeah,
I
which
remember
created the ICC.
The Senate president that time was Juan Ponce Enrile.
I don't recall, maybe.
I checked it, sir.
Yes, okay, so it's
He
Juan
was
Ponce Enrile.
he was the Senate president, and from my research, I remember that he was cautioning the Philippines, the senators, against signing. Fixing your signature in the Rome Statute because this is tantamount to having a president or a leader be tried by the International Court.
Correct.
Yun po yung kanyang sinabi
Yes.
nun. Okay.
Well, if under certain circumstances, when you're a victim and you cannot see the justice system working then you have the resort to the ICC. In fact, to me, Edwin, Pinky, the ICC, the charges and the arrest of Duterte is an indictment on our Philippine justice system, because we could not try, for various reasons, the deaths of 3,000, 6,000 extrajudicial killings. So it is an indictment, you know. Let's not kill each other. Do you think Duterte could be tried here under the present political situation, under our justice system, under our law enforcement system, for all its warts? You cannot.
Again, as mentioned a while ago, there's a lot of arguments, and it's going to be quite siguro interesting to find out your thoughts on the various arguments rather that have been raised. One is is it a red diffusion, a red notice, or an arrest warrant? But I asked you, you both said the arrest warrant is legal coming from the ICC. Number two, let's talk about this Article 59.
Which one?
Article 59 of the Rome Statute, basically saying that the arrested person shall be brought before a competent judicial authority. This is the argument that has been talked about over and over again, and even in today's hearing. Bakit hindi dinala si dating Pangulong Rodrigo Duterte sa isang competent judicial authority? Senate President Drilon, ano ho ba ang competent judicial authority?
Well, you know, the administration was invoking a law which gave the government the option of either surrendering him to the competent judicial authority like the ICC, or, surrendering him to the competent judicial authority, which is the local court,
right,
or surrendering him and waiving our sovereign right to try him in our jurisdiction. So there is an existing law.
Which you're talking about, the international humanitarian law. Is that
Yes,
one?
yes.
Okay.
So, yeah.
But before we go to the international humanitarian law, but when it says that a person shall be brought promptly before the competent judicial authority in the custodial state, which shall determine A, the warrant applies to the person, B, arrest in accordance with proper process, C, person's rights respected. They have been talking about this over and over again, Attorney Edwin also, because tinatanong po nila bakit hindi dinala si dating Pangulong Rodrigo Duterte sa isang judicial authority. Please explain this to us.
The idea of when Senator Drilon invoked the international humanitarian law, you're not limited to the ICC because there are a number of laws which you can apply to that. It does not mean that we respect also international humanitarian law. Assuming that was invoked, then that can also be used as a basis to effect the arrest. It's not porque it's only with ICC, then it's that, because we are signatories of several treaties, and one may not necessarily, one is not inconsistent with the other. Just because it's found in another law, for as long as it's applicable, then you can invoke that. And that's how the Philippine government invoked that.
So with setting aside the international humanitarian law, you don't think, Senator, this is a problem that he was not presented to a proper judicial authority, a competent judicial authority?
The administration would argue that they had options, and they chose the option where he was brought directly to the ICC, and that is an option available to the government under the domestic law.
So you don't think this will be a problem?
It will be the ICC who will resolve it. I don't think it will be a problem.
All right. We're going to take a very short break. We'll be back with former Senate President Franklin Drilon and former Presidential Spokesperson Edwin Lacierda. Stay tuned. This is On Point. Welcome back. You're still watching On Point. Still with us, former Senate President Franklin Drilon and former Presidential Spokesperson Edwin Lacierda. One more point about this Article 59 of the Rome Statute, where the arrested individual should be brought to a competent judicial authority. Justice Ascuna was present during today's hearing, and basically he said, or he had implied, from my understanding, that the former president should have been brought to a local court under that article. Otherwise, he calls there could be an abuse of process. However, he, I think, went on to say that pagdating sa international court, iba na yung usapan na yan. Yun lang po. I just want to react on that.
As I said before the break, the government had the option of surrendering sovereignty insofar as or surrendering sovereignty insofar as the trial is concerned to the ICC, and that's allowed under the law. There's an existing legislation on that. Now, I don't dispute the argument of
Justice Ascuna.
Justice Ascuna. But at the end of the day, it is the ICC who will determine whether there was jurisdiction or the former president is correctly brought before the ICC.
Quick, Attorney Edwin.
No, but I agree with Senator Drilon. It's also basically those questions we can answer those questions. We can definitively decide on that because eventually, like what Senator Drilon said, you're going to question that before the ICC and this whole discussion on jurisdiction. That's fait accompli insofar as the Philippines is concerned. You go to the ICC, and that's why Attorney Kaufman is supposed to argue that point before the ICC and let them decide.
And the law that you were both talking about is, again, international humanitarian law. Also often talked about, RA, excuse me, 9851, which states this: authorities may dispense with the investigation of another court if another court, rather, is conducting the investigation. The authorities may surrender or extradite accused persons to the international court. This is what you're both talking about. You know, the talk of extradition and surrender was also lengthily discussed a while ago. Maaari ho bang i-extradite ang dating Pangulo from here to the ICC? Because Secretary Boying Remulla was basically saying you can't extradite him. He's in the Philippines. Tama ho ba yun?
Number one, when you do extradition, it's an extradition treaty between two states. And ICC is not a state. So that's why you have extradition treaties with another country. So that's one point. So the other thing is ICC has its own rules. So we submit to the jurisdiction of the Rome Statutes, and by signing that Rome Statute, by Senator Drilon signing that, he committed the Philippines to the rules and regulations of the Rome Statute. And that's where that is. And also, we, like what Senator Drilon said, we have options and we apply whatever law. We are entitled to choose what option we can do to accelerate or expedite the arrest without violating any existing law in the Philippines, because exactly international humanitarian law was a valid law passed by the country.
But would one supersede another? I mean, I know Attorney Edwin was saying that the laws cannot contradict each other, but could there be an instance that pwede silang magbanggaan and one is higher than the other or supersedes the other?
Well, if it's a constitution, all laws, all domestic laws must be subservient to the Constitution. Now, if there are two conflicting laws, generally you try to reconcile. If you cannot reconcile, then the latter law becomes the more controlling law.
The latter?
Yes, there is an assumption if you cannot reconcile the two laws, you rely on the latter law as having repealed the earlier one.
I see.
That's the rule.
Case of first impression, the DOJ, you know, it's also important, Senator, because you were once DOJ Secretary, and ang humarap ho talaga kanina at nagsalita, apart from General Torre, the PNP-CIDG chief, was Secretary Boying Remulla. It actually went to this message, actually, from I think it was a DOJ Secretary that said this. Let's play it.
Nandito na tayo eh. Executive privilege ka dyan.
Bakit naging executive privilege?
Kanina sinabi mo, PCTC ang nagbigay ng order. Ngayon, executive privilege ka.
Sino-sino na tinuro mo?
That's why we didn't want to attend the last hearing, because this is what we were expecting, ma'am. We didn't want to be bullied into a
No,
position.
we're not bullying you, sir.
Nobody's bullying.
We're not
I
bullying
think
you,
that
sir. We're not bullying you, sir.
you're trying to make people admit something that they will not admit. And executive
we're
privilege is a
trying to
valid
derive
excuse
information.
not to answer any
Secretary
question.
President Duterte is already at the Hague.
Tapos na
We are
ang
asking kung
boxing.
sino nagpadala doon sa kanya.
Sino
Yun ang
nag-order?
tanong
We're
natin.
trying to understand every step of
As
the
I said
way.
earlier,
So actually, the question there really was, they were asking General Torre and then General Marbil, sino ang nagbigay ng order? Who ordered na dalhin ang dating Pangulo doon sa Hague? Doon po nagkaroon ng a little bit of attention, to which nagkaroon nga ng, I think it was General Marbil who said, we're going to invoke executive privilege. Is it important to find out who ordered that, or is that implied?
Well, I think the refusal to say it was the president is dictated by political considerations. Let's admit it. President Duterte is still very popular, and the President Marcos has determined that to the extent that he can avoid being pinpointed as the brains of all of this, he will pursue that. But come on, we're not born yesterday. Do you think the police will move on such an important, critical, political move without the clearance of the president? Come on. So I cannot understand why the president cannot be forthright and say, yes, I directed it. It is to the interest of the 6,000 those who suffered from extrajudicial killing. We must give them justice. And unfortunately, our justice system, with all its warts, cannot successfully give justice to these people. That's an admission. I cannot understand why he cannot say that.
The issue on executive privilege was extensively discussed in the case of Neri versus Senate committee. And
Balikan nga natin yun kasi again, palagi siyang pinag-uusapan. You were Senate President that time?
Yes.
Is that correct?
I can't remember if it was Ponce and Drilon or me, but
No,
anyway.
you were
yes.
the one.
I was the one.
Okay,
have so
background.
many.
When was this and what happened?
This was the issue on the NBNCTE deal.
Yes.
Under President Gloria
When
Macapagal.
Romulo
Yes.
Neri was subjected to 11-hour questioning.
Sorry, he was the NEDA Secretary General,
That's
if I'm not
correct.
mistaken. Okay.
So there was a discussion on the contract with NBNCTE and I think Romulo Neri, if I recall, Senator Drilon, that he mentioned there was an offer of a bribe, 200 million.
That's correct.
And so
There was an offer of a bribe of 200 million from a high government official, and he reported this to the president. President Gloria then. Gloria, according to his testimony, said, do not accept it. And having said that, the Senate, we pressed him. Can you give us the details of whether the President Gloria directed you to expedite or to follow up? Did she follow up? Did she tell you to approve the contract, etc.? And they invoked executive privilege. And the Supreme Court sustained that argument. And here, I think the decision of the Supreme Court is a bad law because it allowed the cover-up of a very corrupt transaction, the NBN transaction. In other words, the principle of executive privilege was invoked to cover accountability so that it was not transparent. To me, this is a bad case. And, well, unfortunately, it's there, and we follow what the Supreme Court said. But nevertheless, it doesn't prevent me from saying the Supreme Court committed an error because they were trying to cover accountability, and in this case, accountability of even the highest official of the land for having allowed this.
on the principles of the Supreme Court decision, which Senator Drilon disagreed with, they invoke fundamentally, or rather, Romulo Neri invoked presidential communications privilege. The whole idea, any discussion with the president is supposed to be privileged. The background behind that is there is, and Frank knows this because we dealt with President Aquino. There should be candor. There should be a privilege. It should be confident because there should be a person should be allowed candor to speak his mind, his or her mind,
yes,
with the president. That's right. That has to be confidential and privileged.
Right.
And unfortunately, in the case of in the Romulo Neri case, the Supreme Court made a distinction between an investigation that is criminal in nature, where you can use invoking the U.S. versus Sirica case of Watergate. They allowed the U.S. Supreme Court allowed the Watergate tapes to be released, violating, sidestepping or overriding presidential communications privilege. Mm-hmm. In the case here, on the Romulo Neri case, it was in aid of legislation inquiry. So the level of presidential communications privilege are not the same. Notwithstanding that, the whole discussion about sino nag-utos, paano nagbago ang utak ni Presidente Marcos sa decision?
Not
Dahil sinabi niya,
cooperating to cooperating.
Gloria.
No. See,
compared
applying
to
it to
now.
present.
Yeah.
Okay.
See, why did President Marcos change his mind? When did he change his mind? These are the questions asked by Amy Marcos, Senator Marcos.
Yeah, okay. But at bottom, that Neri case is the precedent. And unfortunately, the Neri case allowed the executive privilege to be used to cover up accountability. And that's my basic
Yes,
objection.
and I agree with that. But here's the thing. You can even, the separate opinion of Justice Tinga in the case of Romulo Neri versus Senate Committee, he said, and even Justice Aquino, Justice Puno asked Professor Agabin, who was a lawyer for the government, for the Senate. He was asked, how critical is it to know those answers to those three questions? It's critical, but you can come up with any legislation even without that.
Yeah, but in exercise of our
Correct.
of our functions,
Oversight functions.
we have the right to inquire to those.
And you know what Justice Tinga said? You know, in the legislative inquiry, if you cannot find answers, I'm paraphrasing him, you can assume the worst the president can do in a proposed legislation. You can assume, for instance, Senator Amy Marcos could assume, my brother changed his mind because it was, in the words of Senator Drilon, there's are political considerations here. It's as simple as that. So you don't have to know why did he change his mind. The fact that he changed his mind, the fact that he used the Interpol as a basis for changing his mind.
To affect the warrant.
So you can change I mean, Senator Amy Marcos, in fact, assume the worst of why the president did it. Because will that be critical in your in aid of legislation? No.
But I guess also it's going to be very important to find out what the decision of the Supreme Court will be in the pending petitions before them on,
What
the arrest and
What
habeas.
the Supreme Court will sustain the president.
All right, we'll see. Maraming salamat po, former Senate President Franklin Drilon. Pleasure to have you, Attorney Edwin. Also, so good to see you. Maraming salamat po sa inyong dalawa.
Thank you.
That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.